Good morning to you, Tracy. Tell us a little more about this judgment, please.
Good morning to the viewers at home. Thanks so much for having us. So today we are going back to court, the Constitutional Court, on the court case brought by the parents of two learners from a school called Pridwin Preparatory School in Melrose. So Equal Education has joined this court case as friends of court, amicus curiae. And the reason why we've joined this court case is to highlight constitutional obligations and duties of private schools, and also speak about the fact that the right to education should always be prioritized.
So remind us what the school did wrong and what it is that the students want now.
So the parents got into like a dispute with the school. The parents made a complaint about the cricket coach, and there were some like disputes, back and forth conversations between the parents and the school. And at the end of that, back and forth conversation, the school decided to terminate the contract of the learners in that particular school. So the issue with that is that learners were not, considered in that process, meaning that when the contract was terminated, they were left with nowhere to attend school. And there were no arrangements made for them to maybe enroll in another school. So those are some of the issues that that Equal Education, represented by Equal Education Law Center, is highlighting. And our submission is focusing on the constitutional obligations and duties of private schools, looking at the context and implications of the increased privatization of education in South Africa, in particular the low-fee schools that we normally see within the working class communities, or in towns in flats like in Hillbrow and so forth. We're speaking about the relationship between the Section 9.1 and Section 9.3 of the Constitution, the right to basic education, and also the obligation that independent schools hold in relation to that particular right.
Then and I should imagine, excuse me, jumping in, that many of these students who are in this position don't have the money to fight it.
Yeah, so in low-fee schools, for instance, most of the parents from the working class will maybe enroll in that education system because of the beliefs that it's better education, especially in townships. Then if you are like a illiterate parent, then it means that you don't even understand the contract that we are signing when you enroll your child in that particular school. Then when you are faced with these issues, it means that you don't even know what channels to use in order for you to fight or argue maybe the decision made by that particular school. So those are some of the, concerns that Equal Education is trying to highlight, that the right to education should always be prioritized, and children's rights should always be prioritized. If the school is to maybe terminate a contract, at least learners should be given a chance to be heard. They should be granted a hearing to hear the side of their story, because the dispute was between parents and the school. And now, as a person who's going to be directly affected, you have nowhere to go, and you are not even engaged in that process of decision making. So we're hoping that the Constitutional Court today will rule in favor of equal education and the parents, and most importantly will ensure that the rights of learners are always prioritized.
All right, Tracy Malawana, thank you.